that all those persons who have B.Ed qualification are not eligible for the purpose of appointment to the post in primary school teachers. My lords, it's a matter of eligibility today. It's a matter of qualification. It's a matter of a policy of the government, which the Supreme Court has today held and quashed the notification by which B.Ed was sought to be included as a qualification for purposes of appointment to the post of primary school teachers. Now, my lords, having said that, I wish to just impress, and of course, my learned colleague Mr. Vigyan Shah is there, and he will take you through the judgment passed by the Patna High Court, in which the facts are very, very similar. He has a copy. It will be easier for him being physically present to take you onto that. But I wish to press before you one simple principle. Today, a large number of these appointments have happened, which is after the judgment had been delivered by Rajasthan High Court. The principle here is a notification issued under a central legislation. The central legislation, the NCTE Act, which sets out eligibility criteria and qualifications for appointment of teachers across the country. This is not a legislation, or this is not something which is within the state. It is done under a central legislation. It applies across board, across the country. Once the High Court of Rajasthan quashed that particular notification, my lords, the notification goes out completely. Any appointment made apropos to that particular notification is bad for that reason completely, because then they are not qualified. The Supreme Court did not stay Rajasthan High Court judgment. The Supreme Court merely said subject to the outcome. Now, my lords, today Supreme Court has upheld the quashing by Rajasthan High Court of this particular notification. So to say that even if some appointments have been made, and particularly having been made after the judgment of Rajasthan High Court has come, which has already quashed this particular notification, my lords, those appointments are clearly bad, because already a central government act, the act under which the notification is being issued, applicable across, has been already quashed. So there cannot be appointments to be made. Today, reliance can't be placed on saying that, well, I have been appointed, but if the appointment has come on a basis of a qualification, first of all, which is not permissible, which is not eligible for the post, and number two, in any case, after the same has been quashed. My lords, I would respectfully submit that these cases are clearly cases today completely Divesh Sharma holds the field. This one or the other ground that has been taken to defer these proceedings by saying that, well, there was first Arnab Ghosh, now some Guddu Singh. Now, Guddu Singh judgment comes out of, if I remember correctly, because I know there's something in Supreme Court, it comes from UP. It relies on a principle of that Maurya, the other judgment, number one. And number two, my lords, this was regarding the cut-off marks. This had nothing to do with this. Therefore, every time when the matter is taken up for hearing, there is one means or the other to deflect that. My lords, I would most respectfully submit that today, in light of Divesh,
all right,
may I make a submission? May I make a small submission?
1 minute, Miss Mona. 1 minute, Miss Mona. I think my colleague Vigyan has that judgment from that Patna High Court. We want to place that. My lords, I'm doing it. He has that physical copy. Please, yeah, that one.
Just a minute. Let us hear Mr. Rupra. Yes. You are appearing for whom?
I am appealing for those B.Ed candidates who are already appointed in the month of March 2023. So, Lord,
I fail to understand why is there so much of opposition from the state to hear this matter.
opposition.
जी तो काफी नहीं 5 मिनट क्या तुम्हें तो मालूम है
Because there is nothing pending in the Supreme Court. Supreme Court has decided the matter.
ये देखने कैसा है
The review has also been dismissed. Don't you think the review has also been dismissed?
My lord, the review has been dismissed.
So that review order, are you disputing that rejection of review?
You place that on record in the compilation, the order. The order has been placed on record.
हेलो
My lord, before going into
कहाँ
the
देख लो
case, my
सुनवाई
lord,
देखना है चल रही
No, the impression from the state is that they don't want to argue.
हाँ बाथरूम में चल रही मेरे में बैटरी भी नहीं है दूसरे दिन देख
We can't compel anyone to argue. Unless there is consensus to argue, we can't hear it. Please be very clear on that point.
It is not saying that we have tried to keep what simple reason. My lord, friend was aware of the detailed order. But if I may submit to the subject to what my lord friend will clarify.
पढ़ना रहा है
Issues
ये एग्जाम चालू
read petitions. Of that order that has been read, अपना क्वेश्चन ऑफ पेपर 23, clarification being filed and disposed of petition. Supreme Court says, sorry, no, we are not entertaining all this.
करंट ये चल रहा है
Fresh petition
खाते हैं एक
the order was the 5th of January 24.
Fresh
लंबी है ना बैंक
I will be at a point.
Actor on to Supreme Court.
Please save us from being.
So, my lord,
That is the request there.
That was
my lords, my lords, may I just point out how my learned friend is incorrect? The last two pages that I just showed to you, page number 32, 33 and 34 are fresh petitions filed on 6th of January. What is, I think on the other side was
let my learned friend file a reply to transfer. No, there's no reply to transfer.
We can't compel any party who does not wish to argue to argue. That's a much.
That the learned senior counsel on Constitutional Law today, he is representing KC Nandan.
Yes,
My lord, there is nothing in KC Nandan. My lord is not sitting here in a BIL. There are no BILs, not in service matter. So at least not KC Nandan's counsel should please sit.
Sorry, we are representing in both the matters. That may not be a correct statement. Mr. Arora is appearing in both the matters. It's not just Sri Nandan. We see the compilation, sir.
Things I want to say. Firstly, not KC Nandan's advocate, not they must sit. There's nothing there, they have no stake at all. Second submission, my lord, is I was making at the outset, lord, that I have made an application to be arraigned as an intervener in the case of KC Nandan, which has been allowed by my lord. But Lord, because KC Nandan appears to have become infructuous, I have made an application in the case of Vipin Kumar Dwivedi also to be arraigned as a respondent. That IA, my lord, of 17229 may kindly be allowed today.
So why has it become infructuous?
Because all the...
Well, who is he to say that it has become infructuous? I am the petitioner. We are the petitioners. Who is he to say that it has become infructuous? If we are pressing for the petition, Malaj.
What is questioning him on? Oh, yeah.
I'm so grateful, Malaj.
Yeah, we will boil all the things, Lord, will boil down to only one case, that is Vipin Kumar.
Where is Vipin Kumar?
Vipin Kumar Dwivedi. Before my lord, he will argue Vipin Kumar Dwivedi. He says he doesn't my learned friend defense counsel please have a look. The relief clause of the PC.
my lords, can I say that let the petitioners address their matter?
And Rohit,
Yes.
as regards both, it is infructuous.
कौन है
Both of them have been appointed. I decided to close orders and please see their relief clause. And I will cite law before the Lordship Supreme Court says I should not enter into these academic academics because these have become academic. Please see the relief. Whether they because the relief which ultimately they had claimed, they have already got that relief. Now, honestly, kindly refer to clause says, paragraph 7. Potential petitions are no petition. Every time we start, must of petitioners are to be must of all the council in case in London. Please not say that anything. Case in London, please be decided first, which is an infructuous petition. Please have a paragraph 7. I'll just read relief clause. Case in London.
Last time, if I rightly remember, there was some submission made by the council for petition.
Not me.
All these appointments are subject to the final order.
There is an order passed by my lords to that effect.
Permit me to clarify
Order passed by my lords to that effect.
Kindly permit me to make one submission.
The petition,
Yes, Lord. I am for the B.Ed candidates. Your Lordship has completed me. In Miss Meenakshi Arora's matter, where yesterday's submission was made that it is not infructuous because it is subject to the outcome, is what the submission was. I'll make it clear, Lord. The writ petition challenges the B.Ed candidates from appearing and getting into the job, and therefore, whoever B.Ed is being appointed will be subject to the outcome of the writ petition, my Lord. There is no challenge to the appointment of a DLED candidate from being appointed. So what is being sought to be submitted here is that DLED candidate who has submitted to the appointment and joined, instead as if it is his joining as a DLED teacher is subject to the outcome. Lord.
That is an interpretation being given by Ms. Mona. Please see the prayers. We read the prayers for my Lord's convenience last time. Kindly see the prayers. And it is not just Kesri Nandan that we are appearing in. We are also appearing in Vipin. We are appearing in both the matters.
Let me allow me to complete the sentence, Lord. The writ petition is not the challenge is to be. This is not a public interest litigation. Once they got accepted the appointment, they cannot pursue with the writ petitions. So therefore, there are other writ petitions which your lordships are anyway going to consider. Lord. This matter
clause 7.1 में candidates. The release which has already been granted. Manoj, please see 7.1. It reads, Manoj, that the honorable court may kindly be pleased to impugn the notification dated 28/6/2018 and 30th/5/2018 issued by NCT making amendments under notification dated 23/8/2018 issued by MHRD, Department of School Education, Government of India, whereby candidates possessing qualification for B.Ed have been made eligible.
That Supreme Court has watched.
Now kindly come to the 7.2. The Honorable Court may kindly be pleased to issue an appropriate writ order direction not to treat the B.Ed candidates as eligible for the post of primary level teacher. This relief has already been granted by the Supreme Court.
What is granted is continue with appointments. Supreme Court has not reseated anybody. Supreme Court has only stopped any fresh appointments and.
No, I'm sorry, that's a wrong statement to make. That's a very wrong statement to make.
Appearing in
That's a
those
very wrong
matters.
statement to make. Because we have produced those writ petitions.
That the state government is not ready to argue.
Because they don't want to argue because they want to protect a specific. They are not wanting to argue for reasons best known to them.
We have done it on that by recording that statement.
Can we see every time the state and every opposite council wants adjournment on one ground or not? This adjournment, my lord, is actually in their interest. They want this person to be continued in violation of Article 21A. Any single adjournment, my lord, should be called on children who are being taught now by the different teachers. Supreme Court must be counted in violation of Article 21A. Now, we make party with adjournments day after day on one count or another, my lord, can we see? Supreme Court did not take an argument. It's a matter for petitioner's arguments.
As far as we are concerned, the judgment is clearly distinguishable on facts, Lord, and also we are very well protected.
Even otherwise, it will take time to be heard.
Because it won't take time, my lords may just give us 5 minutes and we'll be done. Just 5 minutes. 5 minutes to show that nothing remains now. Just 5 minutes.
Not made any submission.
So much of opposition, even on hearing. Imagine what
Because for obvious reasons, because they are placed. And for obvious reasons.
Energy transfer petition is actually miscarriage of justice when you are moved and application. To the Supreme Court. There was no order. It's a writ petition filed under Article 32.
Because I am appearing in that writ petition, Gundu Singh, there is absolutely no connection. I am appearing in that matter. For some of the DLED candidates, there is no connection of issue. And my lord would recall that every time there is a new ground coming for adjournment. Why? Because these DLED candidates are serving.
Said that Anna Ghosh is not decided your civil dealing on marriage. Anna Ghosh was dismissed. If they were heard, Anna Ghosh was dismissed. The lodgement order says that the consequences were to follow. No person who was appointed cannot be saved. There is a man of silence that in Anna Ghosh. Correct this statement. Absolutely incorrect. I just found that no respondent being said that. It is clear that both applications for recall of the people of the order passed by this honorable court
in the guise of filing the present insurance application. The clear weight in these applications itself would make it clear that applicants intend to seek for re-hearing of the matter on merits after reviewing the order dated 11/2022, which is confirmed is under law.
But re-read petition.
But as far as we are concerned,
All right, please start your argument.
Very well, my lord. So grateful.
We deal with the objection. We deal with the objection. We will deal with the objection. We will record that you are not cooperating. Yes, please start argument. Please start.
I'm respecting from myself. Your Lordship, the time is government.
Before he starts his argument.
I started my argument.
Let him start.
Started my arguments. I am not guilty. As per law.
We will call for your application, whichever is filed is not here with us. No, it's not uploaded. It's not on record. No, we will not see that. We will see the one which is filed. We call it whenever it comes, we will see. Till then, let's start arguing.
Please see page 16 first, the application that was filed by Arnab Ghosh. Please see 16 for a minute, and then we can come to 18.
Wait for a minute. This is page 18 of the compilation. We are saying or anything. It's Devesh Sharma versus Union of India.
Ask him to join in whenever, but we can't.
Take it up in the next week.
No, I'm sorry. I'm sorry. We reject that prayer. If you want, we can put it down and write. Please start. Please start your argument.
Started my argument. To page 18, number 3. Now, Mr. Gadial, would you please allow me to make one which I senior counsel, I hope and I request we have to learn from you.
Mr. Counsel, please leave it that to the court. Handle Mr. Gadial.
There is no objection in it. I'm only saying the case they can decide first, but this has been let him argue the other matter. No, but his case is an case for
Which case are you arguing?
I'm arguing it between parties.
he didn't argue for a
Where is that? That is WP.
but that is second case. That is the next case. First case is case 11. And I would like to make the law for your law as far as criminal is concerned.
But I not take constant to the files because there is a compilation and
28.1. 28.1.
Yes, there is 38.
तो मीनाक्षी
that is
मैम
actually
को
trade.
आर्ग्यू कर रहे हैं तो बोलो चुप रहे बीच बीच में अपन आर्ग्यू कर रहे हैं उसके बीच बीच में बोल रहे हैं इसको चुप करो हाँ ठीक
Parties list Vipin Kumar is 32.1.
Now, yes, I just need your lordship to be.
Leading has been placed.
Yes.
Now, your lordship,
Yes. Yes, please.
please come to the prayer at page 70. This was the prayer,
17.
page 70, running page 70. This prayer number 8.
In Arnab Ghosh.
45 of the clarify that any process that is commenced prior to the judgment immediately for the passed by the Solitary Court in civil appeal number 5. The appointment shall continue to be made as per recruitment notifications for recruitment of library teachers issued prior to the judgment dated library 2023. So by this, prayer matters it is very clear that all those processes which have initiated the appointments being made should continue and the judgment in itself commenced, concluded whatever was meant to. I'm making my submission. You may counter it. Now, Maharaj, can you come to the next page? The third paragraph. The judgment dated 25/11/2021 passed by the Division Bench of Honorable Rajasthan High Court.
Where are you reading?
This is page
18.
Yes.
This is the order dismissing this application.
The judgment dated 25/11/2021 passed by the Division Bench of Honorable Rajasthan High Court was challenged to the Honorable Court in City Appeal number 5/16/2020 and connected appeals. Apart from the said appeals, petitions filed under Article 32 of the Constitution of India dealing with the same issue were also tagged with the appeals. The NCT notification and issue notification dated 28/6/2018 exercising powers under Section 23(1) of the Right to Education Act 2009, making B.Ed degree holders eligible for appointment to the post of primary school teacher class 1-5. When the advertisement was issued on 11/1/2021 by the Board of Secondary Education State of Rajasthan, it excluded B.Ed degree holders from the list of eligible candidates, which came to be challenged before the Honorable Rajasthan High Court. The notification dated 28/6/2018 issued by the National Council for Teacher Education came to be requested by the Honorable Rajasthan High Court, which held B.Ed degree holders to be unqualified for the post of primary school. Thus, the issue that arose before this Honorable Court was whether hence National Council for Teacher Education was right in including B.Ed degree qualification as an essential qualification for appointment to the post of primary school teacher level 1. After detailed consideration of rival contentions, this Honorable Court was pleased to dismiss the appeals and confirm the judgment passed by Honorable Rajasthan High Court dated 25/11/2021. It is specifically observed that the Honorable Rajasthan High Court has followed the settled legal position and no interference is called for. The said civil appeals have been dismissed in terms of reportable judgment. This Honorable Court, by disposing of the said appeal on 11/2023, inter alia has been pleased to pass the following order. What the Rajasthan High Court has stated above is a central legal position. In a recent judgment of this court in state of Manipur versus V. Suraj Kumar Program and others, this position that a statute is being made by competent legislature is valid till it's declared unconstitutional by a court has been reiterated. Consequently, the appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28/6/2018 is hereby twice set aside. The writ petitions and all pending applications stand disposed of in light of the above order. The present application for modification of the clarifications filed by applicant Mr. Kandam Ghosh. The prayer made is to modify the judgment dated 11/8/2023 passed in civil appeal by clarifying that the appointments to the post of primary school teachers shall be made as per the recruitment notifications issued prior thereto. This may kindly be marked. For the other applicants, Mr. Achanta Dhara and Ms. Tanishta Das, who intend to come on record through impediment are persons belonging to the state of West Bengal and B.Ed degree holders are aspirants to the post of primary school teachers. They have applied pursuant to notification dated 23/12/2022 issued by West Bengal Education Board, which is subject matter of challenge before the Honorable Kolkata High Court. It is well settled that applicants cannot seek for review or recall or modification of the order passed by this Honorable Court in the guise of filing applications. Getting the tendencies of the litigant in prolonging and indulging in endless litigation, this Honorable Court in the matter of Indian Council for Environmental Action versus Government of India, and then matter of referring all these judgments.
25 directly, 25 last part.
Is 25. It is clear that the applicants in both applications intend to seek for recall of the review of the order passed by this Honorable Court in the guise of filing the present application. The prayer made in these applications itself would make it clear that applicant intends to seek for rehearing of the matter of merits after reviewing the order dated 11/8/2023, which is impermissible under law. This Honorable Court has been pleased to reiterate the law and confirm the judgment passed by the Honorable Rajasthan High Court, and necessary consequences would follow. This may actually be
Which appointments made 10 years ago will
do
also
not accept what I am saying in my duty.
They are wasting the valuable time of this law. Saying something which is not still in the order. Means it does say consequences the appointment
मना किया
The applicant intends to re-educate the matter of filing instance application for clarification of the modification which cannot be permitted under law. The other applicants were aspirants to the post of primary school teacher in West Bengal Education Board were not parties, and even according to their application, their challenge is pending before the Honorable Kolkata High Court. The aforesaid principles consistently laid down by the Honorable Court would reveal that no application seeking for review, recall, modification of the order of the judgment under the same is not enforceable in law. When the said principles are applied to the present application, it's clear that applicants are attempting to re-educate the issue and obtain indirectly, which could not be obtained directly from this honorable court. This is very important, my lords. There are absolutely no reasonable grounds made out to the applicants to entertain these applications. For all these reasons, I refuse to receive the present application as it does not disclose any reasonable cause for being entertained and they were dismissed. Now, my lord, this order of lodgement was challenged at page 27. This is one of last occasion respondents' record that the matter is pending in unknown courts. I take your document to the last order sheet. Your lordship may now kindly mark this. IA number, please come to the prayer at page 28.
Yes.
That slightly include order dated 22/9/2023, passed by Learned Registrar, just listing MA diary number 36321 of 2023 and directly Learned Registrar to register MA diary number this and this. However, this matter was referred to the bench which delivered evasion last case at page 29. Justice Anuruddha Bose, Honorable Justice Sudhanshu Thulia.
The date is important, 11 January.
11th January 2024.
काला है कि नहीं काला
On 11th January 2024, after hearing all the parties in this prayer,
Please say the prayer also, please.
it is the ideal challenges logical order. Dear Lords, after hearing them, kindly see at page 30. We are not inclined to entertain this application, this application. Now, my lords, at this juncture, I will please come to your Lordship's order of 4/2024 in case Srinandan and other connected petitions. If your Lordship come to the 4 January 2024 order,
Yes.
kindly see, my lords, after hearing learned counsel for rival parties and facts which have been brought to the notice of this court, that an application for clarification hearing MA number 2206 of 2020 is still pending consideration before Apex Court and is tentatively listed before the bench on 11/1/2024. As per the website of the Supreme Court, it would be appropriate to await the verdict of Apex Court. Anxiety has been expressed that cleared appointees were filed MA 2206 of 2023 before Apex Court may delay the matter by keeping the said MA pending for long. In view of this court deems it appropriate to observe that on the next date of hearing, if no clarification is granted by Apex Court, then this court may be free to decide the matter on merits. Interim relief may need to continue till next date of hearing, and then the matter will be listed on court. So now this very MA, which was in Lordship's omitted, this was dismissed by the very same bench which delivered the judgment in the case of Devesh Kumar.
He has not finished.
Hello, order.
No, we can't have arguments piecemeal.
Now, Maharaj, when this was done, things now which has become very much clear is that the B.Ed candidates were the beneficiaries of all those advertisements issued prior to 11/2023 approached the Honorable Court in a pretext that judgment of Devesh Sharma should be treated to be a matter of prospective overruling. All appointments made, all process initiated, they should terminate in the benefits of the B.Ed candidates being treated eligible till the notification was quashed. Now, Maharaj, that clarification, the lodgement order was dismissed, the application was also dismissed. Now, Maharaj, without wasting the lordship's time, please come to the judgment of High Court of Patna, which was with the very similar position which your lordship was seized with. The lordship may kindly come to compilation page 36. And I'll take your lordship to the page 43.
Yes.
Please come to Maharashtra fact from page 6 by 2023.
कहाँ लगन लगे बीएड वाले
The writ petitions, your lordship got it?
Yes.
The writ petitions agitate the issue of certification of candidates having B.Ed from any national policy for teacher education for appointment as teachers in primary schools holding classes between 1 to 5. The stipulation to entitle B.Ed qualified candidates made applicable for teachers posts in primary schools came by way of a notification issued by NCT on 28 June 2018, which has now been set at naught by the Honorable Supreme Court in Devesh Sharma versus Union of India. The writ petitioners challenged the notification before this court by the appropriate petitions in year 2021. In the meanwhile, a similar challenge raised before the Rajasthan High Court was allowed by judgment dated 25/11/2021, rendered by a division bench of that court. It was said that judgment challenging the safety was which resulted in the decision in Devesh Sharma Supra. In the above petitions by order number 3 dated 16/7/2021, the division bench of this court permitted the respondents to carry on with the process of selection and appointment during the pendency of the writ petition, but made it subject to the outcome of the writ petition, and also stipulated that the candidates selected and appointed shall be made aware of the pendency of the writ petition. Exactly the same situation. IA number 1 of 2021 filed on behalf of the interveners who were B.Ed qualified to implement as party respondents in the main writ application for disposal of without allowing the prayer for treatment, but reserving liberty to file afresh if the need arises. However, the applicants were permitted to assist in the matter. It was also directed that the London Council would be sent a link of the proceedings for online hearing. A further including petitions seeking permission to be included as petitioners to support the cause of those qualified with the diploma in elementary education was rejected. But yet another division bench as per order number this and this. Now your lordship may kindly come to para 6. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out. The lordship are getting para 6.
At page 45.
Please come to para 6, the very same position. A preliminary objection was raised insofar as the selection having been proceeded with and appointments having been carried out, none of whom are before the school. However, it has to be noticed that the selection was proceeded with on the basis of the amendments made to the rules of the state in accordance with the modification brought about to the essential qualification by the NCT in the year 2018 by virtue of interim order number 3 referred to. The division bench had categorically observed in the said interim order that the pendency of the writ petition shall be intimated to the candidates selected and appointed, and they shall not claim any equity since that selections and appointments were directed to be carried out only subject to the outcome of the present writ petition. So, one of the very same position here, we challenge the state rules, we challenge the NCT notification, the lordship passed an interim order that the appointment shall be subject to the outcome of the writ petition, awaiting the Devesh Sharma's final verdict. The interveners who support the cause of clear candidates are before us, and despite the findings of the petitions having been communicated to the appointed candidates as vowed by the government advocate, none except the interveners herein have sought implement. They have all been adequately educated before this court. There is no scope for any further directions to be issued for implement of the affected parties, who, despite intimation of the pendency of the petition and their appointments, being subject to the final outcome, have not here to get themselves implicated. We proceed with the matter, especially noticing that the issue is no longer res integra going by the decision in Devesh Sharma Supra. Chief Nigran Moli, London Senior Counsel, however, pointed out that though there is no
all right, we'll see. Continue on the next working day. What's that?
But I 29 to not we are it may not be taken over, we take it after that.
Sorry, Milord. Sorry.
There is some urgent matter which has been said. The supplementary list is coming in 2 minutes. For 2 minutes you can continue.
On Monday, then I'm staying for on Monday time. Monday the next one.
Because if I adjourn your matter, then I will continue for 2 or 3 minutes till the supplementary list comes.
Lord, we will also make our submissions that it can be distinguishable on facts. Devesh Sharma and MP has its own rules.
Yes, you will get your chance on the next one.
Lordship, kindly now come to that paragraph.
You were where? Para 9?
Para 7.
7.
7 and 46.
Regard following practitioner of the law pointed out that though there is no specific express statement as available in the judgment, the fact that the Honorable Supreme Court, while deciding Devesh Sharma Supra, has in the operative portion found fault with the state government for not having permitted the EA candidates to participate in the selection that was notified in the state of Rajasthan. This action of the state was held to be improper since the constitutionality was not being decided at that point of time. This made the decision prospective in nature, and hence the instant selection and appointment carried out prior to the judgment would have to be upheld by this honorable court. So Maharaj, there's the very same position that whatever has been done should be saved. Then Maharaj may kindly see. Further garner support for the proposition of prospective overruling. The learned senior counsel placed lines on Soumya Organics, Kailash Sharma, all these Maharaj. Reliance is also played on all these. Then your Lordship may kindly turn to para 13 at page 49. There, Maharaj, the Honorable Division may start noticing the facts regarding coming out of this notification. We have to notice the notifications from there, Maharaj. Dealing with Ramcharan Maurya, Devesh Sharma, all those judgments. Now your Lordship may kindly come. Page 20, para 19, page 55.
Page 50. Right.
Page 55, my lords. Page 55.
Sorry, page 58.
Yes.
Para 24. Now the question arises as to whether there is any justification for the argument that the declaration made in Devesh Sharma's surprise prospective view. Soumya Organics applied the doctrine of prospective overruling and referred to Golaknath when the parameters of such power were laid down in first instance. It was noted that Golaknath laid down that the doctrine of prospective overruling can be invoked only in matters arising under our constitution. It can only be applied by the Honorable Supreme Court, and the scope of the retroactive operation of the law declared by the Honorable Supreme Court superseding its earlier decisions left discretion to itself to be molded in accordance with the justice of the cause or the matter before it. Prospective overruling was found to be a recognition of the principle that the court holds the relief claim to meet the justice of the case. Justice not its logical but in its equitable sense. There is no such express declaration made by the Honorable Supreme Court in the Much has been argued about the Honorable Supreme Court having noticed that Rajasthan government when issuing an advertisement had not included the qualification of B.Ed candidates, especially when they were made eligible as per the statutory notification of the NCT, which was also binding on the Rajasthan government. This impliedly indicates the prospective overruling is the contention raised, which we are unable to accept. The above observation was only in the context of Rajasthan High Court having set aside the notification dated 28/6/2018. In the operative portion of its judgment, and the state government could not have ignored the notification of the NCT while issuing the advertisement. The Rajasthan High Court had been clearly stated that since the notification itself was declared illegal, the issue was only of academic value.
We'll take it up on the next
one.
My lord, consider recording it as a part heard by the petitioners.
Case stands part heard. That the case be taken up on Monday. Hearing the remaining part of it.
Grateful, my lord, deeply grateful.
Application state which has been filed today. Today, IA number so and so shall also be for deferring the hearing of this petition shall be taken up on the next date of it.
Instead of that, I know one more statement of it is proved to be all out.
Why did the other side agree?
It's fine. And that's why I wait for members of the writing. At least for 2 days, at least for 2 days, even the members. So now, after the part,
Now memory will fade.
After 1 week, the actual memory.
No.
Only the camera was taken up on time. There was something also aware that they would talking about by that time.
3:30.
Camera was taken up on 3 before 2:30.
You make your arguments concise, precise.
This judgment on it covers every aspect.
Camera law covers every aspect. One is digest problem, but my record will not agree to that. Camera law taken up after the partner now. Before the
So you are opposing any kind of further adjournment.
The argument that has happened, they have it's very
Grateful, I was deeply grateful.
Your Lordship, the fixing 3:30 minutes.
My learned friend is very I will like to first. Then anything is required, then Lord. I just want to clarify that what
You are an intervener, Mr. Rupra. Interveners only have a right to audience. That is all. You are not the main man. We are the main contesting responsibility.
That's why I was simply suggesting in one case.
Your Lordships will hear me, my lord. My pleading has been allowed. Not Lordship, you hear me now.
My lords have got the gist that why is there being so much of delay that is being caused, my lord. So 29th would be a good date to hear.
My lord, my lord, in the case of Vipin Kumar Dwivedi, please allow our IA 17229 today.
So we oppose any application being allowed at this stage.
Similar applications of Mr. Chitya have been allowed. My application may also be allowed. Next time I again face some action like this.
We vehemently oppose any such application.
You are for?
I am for that candidate who has been appointed this election from March 2023. This person has become intervener in KC Nandan, but KC Nandan may not release the arguments because contestation has been taken. So, not harmful suggestion that this application of mine to be arrayed as a response today allowed. I'm sure no learned man will not object to
I
that.
will hear you after you can distinguish this Patna High Court's decision.
Not just Patna High Court, but the Uttarakhand High Court has also followed it. So the Uttarakhand High Court has also taken a view similar to Patna High Court.
Let them separate those judgments. Not we'll distinguish them. We will distinguish them.
Final argument is taking place, Lord. IA 17229.
Patna High Court judgment has been tested in the panel.
Not tested, my lords, but a similar writ petition has been filed in the Supreme Court, and that writ petition has been dismissed with a stark prayer.
Very material.
My Lord, I take it up on the flip. First, barter cannot be only
not today, not today. Not today, on the next one.
What's the effect
on the next?
Of Arnab Ghosh and effect of Kuttu? My learned friend has wrongly put all this on the people. Responded when the last hours.
But you will get your chance to argue.
They are misleading people. They are saying that we are violating on the data. He should have outside or disclose this time that the judgment is under challenge. I'm not take it up on fifth parak.
No. We'll forget it. We'll forget everything. Forget everything.
But the intention of the state seems to be clear in this. 29th will be a good month. Grateful, Malos, deeply grateful.
Lordship, take it up. My IS stands allowed to be that favor my kind.
No, not you. It's kept pending. We'll take that up also.
Not trying to allow the same application to Mr. KCR.
We'll recall that order.
My lord,
I'm here, not asking Lord. So otherwise,
my lord, are not available for the week after that.
It can be 29th or at best 30th.
Because 29th is good, Malos. Either way, the petitioners will have to conclude. They can argue on 30th if required.
Let it be 30th. Let it be 30th.
I'm not taking about 29, but they will be complete plus 30.
Because we need at least 20 minutes to complete, so petitioners can complete on 29th.
We'll accede your request to the extent of 30th. That is all. Not beyond that. Tell you.
Lordships are fixing a time, my lord. Lordships are fixing a time. Lordships are fixing a time, my lord.
Very well.
Very well.
Before that, my application will be considered on 25.